Taylor Swift has been dragged into Blake Lively's explosive lawsuit against Justin Baldoni, with lawyers on one side pushing to put her under oath and her own team insisting she has no meaningful role and would only appear if a judge forces it. That headline sounds like a friend taking the stand in a Hollywood showdown, but the reality is a lot colder. This is a discovery chess match where names become leverage, calendars become weapons, and the loudest move doesn't always win. Most people hear Taylor is being deposed and picture a star witness marching into court to blow the case open. The common belief is that she's picking a side, that Blake gets a power boost, and that Baldoni is suddenly on the ropes. But look at how these things actually play out. A celebrity's name shows up in a letter or motion. Someone says she agreed to sit. Her lawyer fires back that no agreement was made and any appearance would be limited and only if compelled. And the entire fight becomes about deadlines and scope rather than a grand confession. That's not friendship drama. That's litigation. Here's what you're going to get from this breakdown. First, what actually put Taylor in play, and what the competing letters and statements really mean when you strip away the headlines. Second, why each side would want her on the record in the first place, and what she could realistically be asked that matters to the claims. Third, how a deposition tug-of-war could change the timeline, the PR narrative, and the careers attached to it ends with us. To do this right, we track the public timeline, the dueling positions summarized by major outlets, and the incentives that lawyers weigh when a non-party celebrity becomes the hottest name in the file. Start with the twist that made this story explode. One side floated that she'd agreed to a deposition date, but that scheduling made it tough to finish discovery on time, so they needed more runway. Swift's lawyer responded that she hadn't actually agreed to be deposed at all, that she'd only sit if ordered by the court, and that her window for any appearance was extremely narrow because of prior commitments. In one move, the word agreed becomes contested, and the supposed sure thing turns into a conditional maybe, tightly fenced by availability and scope. The shock isn't that a celebrity might be asked to testify. The shock is how often the supposed agreement dissolves on contact with a formal response. That's your first tell that this is about pressure as much as proof. Now, ask the only question that matters in a discovery fight. What unique, non-duplicative information does Taylor Swift have that can't be obtained from anyone else? She wasn't managing the set. She wasn't overseeing HR. She doesn't run the studio. Her involvement with the film was cultural and creative, not operational. So, at most, a real deposition, if one happens, would likely aim at communications she personally had about specific issues, what she knew and when she knew it, or whether anyone attempted to use her influence in a way that touches the claims. That's not a sweeping interrogation. That's a narrow lane, measured in hours, with lawyers objecting every time the questions drift into fishing territory. So, why push for her anyway? Because even a notice aimed at the biggest pop star in the world generates attention, and attention changes leverage. Announcing that you want Taylor Swift on the record drives the story out of the business pages and into the bloodstream of pop culture. It puts pressure on schedules, it strains the other side's bandwidth, and it forces a time-consuming side battle over scope. If you believe she has nothing to add, that might be the point. The value of the ask isn't always the answers you get. It's the clock you move, the headlines you win, and the legal fees you force the other side to spend while you hunt for daylight. If you're Blake Lively's side, the strategy is almost the mirror image. Lock the calendar. Keep discovery contained. Frame any attempt to drag in a non-party celebrity as a spectacle that distracts from the core claims of harassment and retaliation. Push for relevance, proportionality, and burden. Argue that the facts live with the people who were responsible for set culture, on-set incidents, HR processes, and production decisions. If the court agrees that Taylor's knowledge isn't unique, the request can be denied outright or cut down to a surgical list of topics and times. That's how modern judges think about these asks. Keep it tight, keep it productive, and keep the case moving. Zoom out and remember the larger arc. This case began with allegations of severe misconduct and retaliation. Baldoni has denied the allegations. The complaint was filed and later amended to add witnesses and communications as the story widened. A trial date was placed on the calendar for the future, a signal from the court that this matter should advance in orderly phases. In that context, trying to depose a global touring artist late in discovery isn't just a subpoena choice, it's a scheduling gambit. Time either becomes your ally or your enemy, and both sides know it. There's a reason non-party celebrity depositions sit behind a higher bar. Courts prefer that parties exhaust the less intrusive sources first: emails, messages, production records, depositions of people who actually ran the set, and the workplace. Only if those routes point to a celebrity as the unique carrier of a particular fact will a judge bless the intrusion. Even then, the court can limit the time, the topics, the location, and the format. Written questions are sometimes used. Protective orders are common. The goal is to get the necessary facts without letting the process become a circus. There's also a history here that explains the defensive tone you hear from Swift's camp. Earlier legal skirmishes reached towards celebrity gravity and were pared back. When side claims balloon and try to turn a workplace case into a referendum on power or influence, judges have shown a willingness to deflate them and refocus on the core. That's the quiet subtext in this deposition fight. If the court has already signaled an appetite for tighter, evidence-driven progress, a late ask to pull in a non-party star looks less like a must-have and more like a tactical squeeze. Meanwhile, the PR war runs on its own fuel. If you're Baldoni's team, simply saying her name changes the slope of the conversation. It reframes the case from a legal dispute into a pop moment and buys you more oxygen. If you're Lively's side, the response writes itself. Respect the process, stick to the claims, stop using headlines to move deadlines. A lot of people underestimate how much this audience management matters. Jurors are drawn from a public that lives in that information stream. Studios, insurers, distributors, and agents track risk through those headlines. When a name like Taylor is invoked, every stakeholder's pulse quickens, and that has ripple effects on settlement talks, financing, and future projects. Money always hides in the margins of these decisions. Every new witness notice triggers preparation costs. Every scope fight spawns motions, meet and confers, and replies. Every extension creates more billable hours and more room for outside noise to seep in. If you're managing a long case, you fight not only for facts but for tempo. That's why, on paper, a 2-hour celebrity deposition looks small. In practice, it can reshape the entire month around it. So, let's game out the most realistic paths from here. One possibility is that the judge denies the request or limits it so tightly that it becomes a non-event. Taylor never sits, or she answers a handful of specific questions in a brief, controlled setting. This outcome supports the message her lawyer has already sent. She isn't central, and the case should stay focused on the people and documents that are. Another possibility is a narrow deposition allowed under strict time limits and topic lists, potentially with a protective order. That gives the requesting side the optics of "we got it," without handing them anything explosive. The least likely path is a broad extension with open-ended scope. Modern courts aren't eager to reward celebrity-driven detours that inflate cost and delay. Where does this leave Taylor Swift right now? Exactly where her team wants her, framed as a non-party with limited, if any, unique knowledge, unwilling to volunteer, prepared to comply only under a court order, and available, if at all, on a narrow window due to commitments. That stance accomplishes 3 goals at once. It protects her brand, it reflects how judges typically analyze burden versus relevance, and it drains drama from the request. If she never sits, the story moves on. If she does, the transcript is likely to read like a calendar rather than a confession. Dates, brief acknowledgments, clarifications, and plenty of "I don't recall" when questions wander outside her lane. Now look at incentives beyond the headlines. For Lively, containment is strategy. You want the allegations judged by the record you've built, witnesses with direct knowledge, documents gathered from the production ecosystem, and a timeline that shows cause and effect without celebrity detours. For Baldoni, the value of raising Taylor may be less about her testimony and more about the heated ads to a negotiation over schedule and scope. For Swift herself, the only upside is control. Set expectations early, define the boundaries, and avoid becoming the main character in someone else's lawsuit. There's a bigger playbook lesson here. If you care about how high-profile cases really work, when a lawsuit morphs into a media war, the side that keeps the judge centered on relevance usually wins the long game. Not the flashiest motion, not the boldest press line, not the most famous name on a witness list. Relevance. Judges read past theatrics to the parts of the record that matter, and they write orders that reward parties who do the same. If you're tracking this case, the words to watch aren't Taylor Swift. They're granted, limited, or denied on a scheduling order. Those 3 words will tell you which strategy the court is validating and how close we are to a real trial rather than a content cycle. So here's the bottom line. Taylor Swift being pulled toward a deposition doesn't make her the star witness of Blake Lively's case against Justin Baldoni. It makes her a strategic variable in a contest over time and attention. The most accurate reading of the public record is simple. She hasn't agreed to volunteer. She'll only appear if compelled, and any testimony, if it happens at all, would be tightly circumscribed and squeezed into a narrow calendar window. That's not a bombshell. That's litigation mechanics. And in high-profile cases, mechanics decide outcomes far more often than viral moments do. If you want the next real update, don't watch for a photo of a celebrity walking into a conference room. Watch the docket for the ruling on whether a non-party celebrity deposition is necessary, limited, or off the table. When that order lands, you'll know whether this was the turning point people imagined or just another skirmish at the edge of a much bigger fight.